question is that this bill be now read a second time. I call the member for Baulkham Hills.
Thank you, Mr. Acting Speaker. And listening to this debate, Mr. Acting Speaker, I'm forced to question whether or not the Labor Party in New South Wales have either got a glass jaw or a very short memory, or they just like to deny history. Because it just appears to me, every time there's a move to amend compensation in this state by this government, they go into complete meltdown. But it was only a few short years ago when I recall the union movement marching on Macquarie Street when they've attempted to change and amend workers' compensation. And if you sit here and listen to the Labor Party in New South Wales, you'd be led to believe that for some reason we are just hell-bent on denying workers' rights. And I would ask the Labor movement, both here and in Canberra, to name me a country which the working man and the blue-collar worker has a better lifestyle, because I, for one, can't find one. I think that in amending this legislation, the Labor movement have once again attempted to go back to revert to form, assuming that this is all about rip-offs and it attempts to deny people appropriate compensation. But it's certainly not. It's certainly not. The New South Wales compulsory third-party system scheme was at crisis point. It's at crisis point the same way that that mob knew that workers' compensation in this state was at crisis point when they were in government. It's why they used to go around to the business community in the previous term of this place and tell everybody, we know workers' compensation's at crisis point, we know the state can't afford it, we're going to try to change it, we just can't get it through our bosses in the union movement, we just can't get it through John Maitland, we just can't get it through the ACTU or the Labor Council, because their paymasters down in Sussex Street wouldn't allow it. But here we are introducing reformist legislation. We're a reformist government introducing legislation that is going to stop the CTP scheme and terminate it from its crisis point, and they're just on the sideline throwing rocks, saying that they're going to oppose it, but they're certainly not going to tell us what specifics in it they oppose, because, you know, I think that some of them need to go through some serious soul-searching and remind themselves what they told the business community in their previous years of government, in their last years of government. Now, these green slips are just unaffordable. Like workers' compensation was unaffordable. Like the police workers' compensation was unaffordable. The same way that in Canberra, their party understands that the compensation and the pension scheme for our defence forces and the CPI increases that our military personnel were expecting were unaffordable. They understand when they're in government what's unaffordable, but in opposition they just want to sit there and throw rocks. This motor accidents and injuries amendment bill introducing the type of reforms which bring this scheme back from the brink. The bill introduces a no-fault first-party scheme, which is very similar to no-fault party schemes we've seen around the world, and the most significant reform this is the most significant reform that we've seen in the last 20 years. Under these reforms, benefits will be available to all injured people, regardless of fault, and that's why you take insurance out, except for those people who are charged with serious driving offences. I find it very strange that the Labor Party are actually opposed to this notion, because they're the party that have well and truly ingrained in the Australian psyche that you've got to blame somebody else. Whenever something bad happens to you, according to the Labor movement, you've got to go and blame somebody else. Let's find someone to sue. Let's find someone to pass on the blame. But here in New South Wales, under a coalition government, we accept the fact that there are people who are uninsurable and should not be covered under a no-fault scheme because they are culpable. They may be suicidal. They may be in some way completely they're completely ignorant of the road rules, and they, of course, should not be covered under a compulsory third-party scheme. However, the Labor Party have got to realise Mum doesn't get in the car deliberately to run up the back of somebody else. She might be at fault, but that certainly wasn't worth her being exposed to tens of thousands of dollars worth of damages. So this will actually allow an estimated 7,000 people a year to have access to more benefits, because we accept the fact that sometimes accidents happen. There are people like any of us here who do not go out to cause mayhem on the roads. Ordinary drivers who may experience a momentary lapse of judgment or fail to respond quickly enough in an unexpected situation will now be covered. The establishment of a no-fault scheme will be more efficient and reduce legal and investigative costs and insurer expenses. And that's where the savings are coming from, Mr Acting Speaker. We understand that the extended, delayed response to the legal question of who was at fault has been one of the primary costs to this scheme. We understand the notion, unlike Labor, that justice delayed is justice denied. We are going to remove the legal and investigative costs and the insurance expenses to reduce the cost of this scheme. And I must say that those that have opposed this scheme that have come to my office have all got legal firms on their letterhead. I was delivered today. Must have been 1,000 names on a petition, one of which was in my electorate, and the letter was clearly marked from a law office. So it's quite clear those that are writing the opposition speeches on this particular matter have been the ones with the most to lose. It will be procedurally fair and robust while minimising disputes and friction costs which currently erode efficiency, effectiveness and affordability. Mr Acting Speaker, if I can just close just to address some of the concerns that were raised by the member for Maroubra. The reforms to the motor accident scheme will reduce the need for complicated disputes. That's where the savings will come from. Legal rights will be protected under the new scheme by straightforward dispute resolution processes and safeguard mechanisms. The bill introduces two streams of dispute resolution. The first stream will deal with a review of administrative decisions in the statutory benefits regime, and should an injured person dispute a decision of an insurer with regard to their benefits, this bill establishes a simple and effective process that will reduce the need for the claimant to have legal representation. I know the member for Maroubra is a lawyer in his previous life. He doesn't like the fact that the legal system will be removed from the process to increase efficiency and to reduce the costs. If an injured person is not satisfied with the decision made by the insurer in relation to benefits, that person can request an internal review of any decision made by an insurer. So the exposure, the exposure from the injured party is not going to result in them having to go and sell their house or their firstborn child. That is just a complete and utter fallacy. Any non-compliance with the decision made under this scheme will be reported to the Motor Accidents Authority. Mr Acting Speaker, and you're aware that the Motor Accidents Authority are no shrinking violets. I have enough faith that they will be able to identify any attempts of maladministration and address it accordingly. Mr Acting Speaker, the legislative changes in this legislation includes the establishment of the New South Wales CTP Independent Review Officer. The Independent Review Officer can deal with complainants, undertake procedural reviews of earnings, decisions made by insurers, and report to the Minister on matters concerning the operation of the Act, or as requested by the Minister. So when they stand up there and say there's no appeals process, this is a complete denial of our justice, they can highlight the fact, I just need to highlight the fact that this legislation allows for a review by both an independent review officer or as requested by the Minister. The findings of the independent review officer cannot affect the earnings decision, internal review or assessment by a claims assessor. The independent review officer will not intervene in disputes already being considered by an assessor or court, which is quite appropriate and consistent with our judicial system. It is our last tier of review after the court has made its decision or ruling. The independent review officer will be funded by the Medical Care and Injury Services Levy. Insurers may be required to meet the complaint or legal costs associated with complaints to the independent review officer. Therein lies a complete deterrent from the insurer to do the wrong thing. The two streams for dispute resolution and the newly created independent review officer will provide an important accountability mechanism for the scheme. The government is committed to ensuring that persons injured in motor vehicle accidents receive compensation quickly and without the need for to pursue lengthy and complex legalistic processes when and if a dispute arises. Mr. Acting Speaker, this reformist legislation has my complete backing. It has the backing of the government. It is the type of reformist legislation that those opposite attempted to introduce when they were in opposition, but they were beholden to special interest groups. They couldn't get it off the ground. I know they wanted to do it because they told me they wanted to do it, and I commend the bill to the House.